First, we claim that the manner in which the hearing was conducted violated Mr. Davis's due process rights. And then second, we state that the statute is unconstitutional on its face. It's both vague and overbroad.
Let me ask you a question before we get into the merits of that. Tell us where things stand now. The injunction or the protection order is set to expire next week. Has there been anything that's happened in the intervening period of time?
There's been no act by Mr. Davis within the intervening time. There's been no request by the Sheriff's Office to extend that order.
So there's been no request to extend, and the procedure under the statute that would allow Mr. Davis to seek an early termination, that has not gone forward either.
No, and it didn't go forward because then you would have still put in place that risk protection order as his reputational interest, because you would have effectively stated, okay, that RPO was properly entered. And now the burden shifts under the statute to him to prove that by clear and convincing evidence that risk protection order, although maybe properly entered, is no longer valid. So no, there has not been a request by him to vacate that early, simply because of those two reasons.
And it's not moot, perhaps, because of those same reasons?
Exactly.
Or it won't be moot after next week?
Right. It's capable of being repeated, but at the same time, once you have that risk protection order entered against you, it goes on forever. It is in NCIS, I think is our NCIC, and FCIC, so it's always going to follow him around as well as with his reputational interest.
Is that, I mean, maybe the reputational interest is there, but on the first point, as I read the statute, which was very curious to me, it says once the order runs its course or is vacated, it's got to be pulled out of the system.
And at the same time, though, if you look at the Section 3C of this statute, if this ever comes up again, if Mr. Davis makes a statement that he does in the heat of the moment, he may not intend, like he did here, the fact that a risk protection order was entered against him previously becomes one of the elements that the judge is told to look at in considering whether a new one should be entered against him.
Which was very interesting to me, and I wonder, you know, how anybody would even know about it if it's got to come out of the system. I mean, it seemed very incongruous there.
I don't see how it comes out of the system. I don't understand that it's going to come out of the system.
I mean, that's what the statute says, though, correct?
But I don't remember that the statute specifically says that it's supposed to come out. I do know that afterwards he gets his,
I'm
if he
reading
can prove.
10D is in dog. If a risk protection order is vacated before its end date,
Before
that's
it's
about vacation, and I think it's also, anyway, I think you've answered my question about where things are. I won't take up any more of your time making your argument.
Well, and Your Honor, to that point, if it's vacated before its end date, so if it's vacated early, then the clerk should forward that to the Department of Agriculture, but that's for his license, his concealed weapons permit. That's not as it relates to the national or the federal or Florida database for what has happened in the past. So I don't think it comes out of there.
Counsel, let me jump in here for a minute because I'm concerned from the standpoint of the trial judge here. And I want to talk about clear and convincing standards, heightened standard. It seems to me that the trial judge just simply gave little weight to the psychological testimony, the pencil and paper test, and really put a premium on the testimony of the fellow officers who know Mr. Davis, ostensibly know him well, but don't have any axe to grind. She was convinced that, in the language of the statute, that he posed a significant risk, whatever definition you want to attach to significant, recognizable, possible, not absolute, not imminent. But how do we get around that and substitute our judgment for she's making a call between whether or not this was hyperbole or whether or not this was based on testimony of fellow police officers, at least a recognizable risk? How are we going to get around that?
I think you have raised three issues on that. First, is it a significant danger? And you stated correctly that this statute does not define it. It leaves it up to the discretion of law enforcement or judges to decide whether this significant danger rises to the level required by the statute. That, at first, is a violation of FOP versus City of Miami by the Florida Supreme Court in 2018. It also is in Dallenberg versus Anderson in 1977, where they say you should not leave the enforcement to the discretion of a law enforcement or judges, because that makes it unconstitutionally vague. Then, if you look at the evidence which presented, this court in 1995 in Wade versus Northeast Florida State Hospital dealt with something similar, and it stated that potential harm without the testimony of prior substantial harm or how that future conduct may produce harm is insufficient to be clear and convincing. This court relied upon one transitory event, the events of March 18, 2018, with the exception of looking at his Facebook post between March 18th and the date of the May hearing. That only thing they relied upon was March 18, 2018. There is similar to Baller versus State, this court's decision in 2000, where it was a scary outburst, a threat, and a slap. We
But
don't
under
even
the
have that here.
statute that we're dealing with here, those are permissible factors for the court to consider. I mean, she looked at the factors, she checked the boxes, and so I understand your constitutional challenge, but under the statute, as it's plainly worded, how did the trial court err?
Well, if you take away the form language of that statute, you're right, she checks the box, and each time she checks the box, she points to the events of March 18, 2018. So if you look at that, now you're looking at, you take away the form language, you look at what she typed in there is what she relied upon. And the first thing she says is she relied upon Mr. Davis's training as a law enforcement officer, both how to use a firearm safely and properly as a law enforcement officer, and crisis management. That's not showing that he's a significant risk. That shows that she's thinking more of a potential risk or a possible risk. She's not looking at an imminent danger. She's looking at a hypothetical danger. This statute, at its core, when the risk protection order is entered, needs to look at future risk. And in 3 places you see that Mr. Landers did not present any evidence of future risk of harm. In fact, on pages 138, 149, and 150 of the transcript, you see his argument where he says, future risk is not even contemplated by the statute. It's not a consideration this court should look at. That can't then be clear and convincing evidence that the court relied upon, which was presented by the sheriff's office, that somehow Mr. Davis poses a future risk. If Mr. Landers intentionally did not present it, and at one point on page 149, the witness talks about future risk and says Mr. Davis does not present a future risk, Mr. Landers' response was, hold on, I didn't ask you about future risk. That's not a consideration for this trial court. So then how could the trial court have seen future risk clear and convincing enough to be able to establish an RPO?
Set me straight on the standard of review, because I'm thinking that the standard for interpretation of the statute is de novo. What deference do we need to give the trial judge in terms of the finding of fact? I mean, the facts are set by her, arguably, and then we just apply those facts to the statute de novo, right?
Yes, that is correct, except under FB versus State, the court says that if this specific issue, the fact that there was that the main element to be established by a statute, or in that case was a crime, has not been established, this court can review that, even without a contemporaneous objection below. For example, what Your Honor said was, well, she gave minimal weight to the expert witness, Dr. DeMary. That was because she did not follow the requirements of 90.616 regarding sequestration of witnesses. Mr. Miller below said Dr. DeMary, who was the only witness that Mr. Davis was able to call at the hearing before the judge left, was essential to the presentation of their case. Well, she didn't make a determination that he was non-essential and then sequester him. Instead, what she did was she said, my general rule is to never let an expert stay and listen to other people's witnesses. That's not the standard under 90.616 subsection 2C. She needed to have made that determination that he was non-essential, and she didn't.
Okay, because on your sequester issue, I think the bigger issue, and the trial judges can disagree on this. I frankly allow experts to sit in and listen to the testimony. I think it's efficient. They can, but the remedy, it seems to me, is that trial counsel needs to bring in his witness and say, Dr. Demery, I want you to assume that while you were out in the hallway waiting, the testimony was, and then fill in the blank with facts that are in evidence or facts that are going to be in evidence, and ask him questions about his opinion. I mean, I would venture to say that that's the way it happens most of the time. So from a harmless error standpoint, didn't that ship sail, I guess, when they didn't ask the questions in that way?
I don't believe that ship sailed because at the same time there was hypothetical of, well, what if this witness said X? But then there was, when he was cross-examined on the deposition transcripts, which had been received the night before, and he was told, go out in the hallway and sit there and try to read through these 6 deposition transcripts. Then he was also cross-examined on testimony that had been either hypothetically or otherwise presented during the hearing. In neither of those times, in fact, on one of the times, the testimony had not been presented. It was supposedly presented through the sheriff, but the sheriff was never called to the stand, and the testimony that was referenced was not within his deposition transcript. So I think what happens is because he was sequestered, he was not able to instantly and immediately recall some of the specific details that he was called upon by Mr. Landers, and that allowed the judge to say that his opinion was formed in a vacuum. But the vacuum was created by her.
But since the judge did not rely on mental illness or any type of infirmity in that regard, why does that make a difference to the sequestration issue? The trial court didn't base its finding on mental illness at all.
Because that was the only witness that Mr. Davis was allowed to call during the hearing. The sheriff's office used about 77% of that time. They called all 3 of their witnesses. Mr. Davis had 3 witnesses present. He was able to call one, Dr. DeMary, who Judge Brasington had sequestered, which we believe improperly.
Right, but your client didn't
ignored.
have the burden in this case.
But at the same time, you have Pope versus Pope and Biling versus Biling, as well as AT&T versus Castro, all decisions from this court that state the most important element is the right to be heard for fundamental due process. And he was not given a meaningful opportunity to present his case. In fact,
I guess it seems to me, and I think Judge Sherritt kind of hit on it, that this case really was a credibility assessment that the trial court needed to make. You had a law enforcement officer who is trained to use a weapon, tells his supervisor, the sheriff of the county, I want to go shoot a fellow officer in the face, eat his food, and then wait to be arrested. And the judge had to evaluate whether the officer was just in this love triangle and is blowing off steam and really didn't mean it, or whether he potentially was going to do that. And I guess none of us up here saw the testimony, heard these witnesses, so how can we substitute our judgment for that of the trial court who did hear the testimony, did see the witnesses, and came to the conclusion that, in effect, he meant that?
Your Honor, I'm not asking this court to substitute its judgment as it relates to the witnesses that were presented. I do believe that his fundamental due process rights were violated because he could not even call 2 of his 3 witnesses. And the standard is, even if those witnesses would not have been impressive, he had the right to call them. He also had the right to present closing argument.
Was their testimony proffered?
No, because when Judge Brasington
So
left...
we don't know what they would have testified to at this point.
True, but that's because based on the transcript, Judge Brasington left, and the way she stated it was that the the RPO was going to remain in place. Mr. Davis believed that there was going to be another continuation of that RPO, the temporary RPO, and then a rescheduling so that he could complete his witnesses and make closing. It wasn't until that afternoon when she entered the RPO and sent it out that Mr. Davis realized for the first time he wouldn't get to call his other 2 witnesses and he wouldn't be able to make closing argument. Your Honors, I see that I'm well within my period of time, so unless there's
Well,
other
I'll
questions.
give you your full 3 minutes since I took up quite a bit of your time on some procedural matters, and we'll add 3 minutes to the other side as well.
Thank you, Judge.
May it please the court, I'm Lindsey Lander, and I represent the Gilchrist County Sheriff's Office. I have with me Robert D. Schultz III, the Sheriff of Gilchrist County. Your Honors, in this case, Judge Brasington found by competent substantial evidence of the RPO statute, and the petition filed in this case was proper, was properly entered. We don't believe that she abused her discretion, and that the parties had notice and opportunity to be heard, and the issues that are raised on appeal related to the trial itself were not properly preserved for appeal. And certainly the issue of the constitutionality of the law was raised improperly because it was not raised in any way, shape, or form during the RPO process itself. It wasn't raised in their answer. It wasn't raised in any pretrial motions. It wasn't raised in trial. It wasn't raised on motion for rehearing. The 1.071 notice that was filed in the appeal was a rule of civil procedure that should have been filed in the trial court. So the Attorney General was not put on notice that this issue even existed or had an opportunity to participate at the trial court level. And as I discussed in my brief in Matthews v. State, that if a constitutionality of a statute is to be considered, then it should be heard at the trial court first, or how could it properly be brought here? So our position is we had a trial. The issues raised are not properly raised before this court, and we're asking the court to.
Well, let me ask you about one issue that I do think is before us, and that is the argument that the RPO was based on one event. It was an historical event. There was no indication, according to their argument, of a future risk of harm. And can you tell me what your response is to that?
Yes. The argument made by opposing counsel, both in their brief and here today, skews the reading of the RPO statute. The only time that it speaks about future harm or risk of future harm is in the granting of the temporary RPO. If the court looks at the actual RPO that is considered by the court at the trial that we had on May 15th, there's no discussion of any factor. There's 15 factors that speak about future harm. However, at the trial, there was considerable testimony from both Chief Manning and Sergeant Jenkins that there had been two things that led them to believe on May 15th that the RPO was appropriate to be entered then, based on their belief and their testimony on that date, not on the March incident date, but on the May 15th trial date. And specifically, that testimony related to Mr. Davis beginning back at least in December of 2017, becoming aware of an inappropriate relationship between himself, or not between himself, but between his girlfriend and Lieutenant Cruz, that between that date and the March, I believe it was 18th incident, that Mr. Davis tracked Miss Kohler's whereabouts, that he would check in, and he testified that it was more of a, I would call her and she would tell me where I was at. But it was clear that, as Sergeant Jenkins testifies, that his feelings festered. And I believe Judge Brazington used those words in her ruling, in her finding of the RPO, that there was a festering continuation between March, or December rather, and the March incident. And both Chief Manning and Sergeant Jenkins testified on May 15th that they believed and they felt that based on that and based on the seriousness of what happened, I mean, this wasn't just a statement made by Mr. Davis, which in and of itself was abhorrent to make to a fellow officer or anyone. He threw all his training and discipline aside. He went in a secure dispatch area and disrupted the dispatch area. So their testimony was based on their observation of what they had found out, and that they felt that on May 15th that potential was still there.
Mr. Landers, let me push you on this a little.
Go ahead.
You know, when I see clear and convincing, well, our courthouses are full of love triangle cases where people come in and they say the most outlandish thing and they blow off steam, and the judge has got to make a decision if it's a real credible threat or if it's just something in the moment. When I see clear and convincing evidence standard, I mean, that's a red flag to me. I think the courts substitute words like the decisions without hesitation. It's unequivocal. Here you've got a situation where I didn't see any testimony in the record about any real pattern or history for violence or he didn't act violently toward any person. I think he beat up on a filing cabinet and damaged a filing cabinet. Then he demonstrates to me a level of self-control and calls his boss to come in and intervene on his own behalf, and he purposely leaves his gun out in the car. And then you've got these psychological evaluations that the sheriff's office initiated that the result is, quote, zero risk of future or potential. And I think we are talking about future here, because that's the only kind of harm the statute can prevent, is something that's going to happen in the future. So I guess being a devil's advocate with you, and you're the appellee here, but how does that all add up to clear and convincing evidence?
Well, I think that the discussion that this panel had with the appellant is important in that the judge had to assess that. The judge heard the testimony. The judge was there. Again, first of all, not an issue raised properly for appeal, so we don't believe that the court can consider it. But to answer your question, the judge was there. She made the determination that Mr. Davis's actions rose to the level of the 15 factors that are set out in the RPO statute.
Well, that's her conclusion. I mean, what are her findings of fact? I mean, she went down and she checked off a few boxes that are sort of conclusory, but I'm all day willing to give trial judges the benefit of the doubt on findings of fact. But somebody, it seems to me, could argue that, you know, the facts are as clear to us as they are to her, perhaps.
Well, respectfully, our position is a little different than I think the devil's advocate question that you posed to me, in that Mr. Davis is a trained law enforcement officer. This is why this was so difficult for us to bring against one of our own officers. Mr. Davis is a trained law enforcement officer. He came to the sheriff's office into a secure dispatch, created a scene that is completely out of line with his training and discipline, that disrupted the only two dispatchers that we had on duty. So luckily, nothing came through during this scene. He either passed out, fell down, tangled up with, he doesn't even remember what happened in the dispatch room, where he ends up falling down and hitting his head. And then he repeatedly makes this cold statement of, I want to shoot these officers in the face, or this officer in the face. I want to sit down and eat his food and wait for the law enforcement to come pick me up. And so our interpretation was that this isn't a minor breakdown or a love triangle, or he didn't call her up and say, I don't agree with what you're doing, or we're breaking up, or I'm mad at you. Or he came to our sheriff's office, into our secure area, and took these actions, and they're repeated them. And the fact that he contacted the sheriff, we don't think takes away from the severity of what he did. And what the trial court did have was two officers who both testified they liked this guy. They were not in any way comfortable being there, and that they saw that his demeanor was so violent, so out of character, that they felt it was appropriate to take the actions they did at that time.
Help me understand your argument about, I think I understood it, or at least it's been characterized, that future harm is not the standard here. I mean, as I read the statute, that's exactly what we're talking about, because it's talking about evidence that the respondent poses a significant danger of causing. I mean, to me, that's a future tense. And to make that assessment of the future tense, we necessarily have to look back at past actions to see if that gives an indication that the future actions will track the past actions. So help me understand if they're mischaracterizing your argument, or if I'm misunderstanding your argument.
Well, again, issues raised for the first time on this appeal we don't think are appropriate to be heard, including this one. There was no contemporary objections to any of these issues that were in the trial, so we don't believe they're properly before the court. But to answer your question, I do think there's a misunderstanding of maybe my position. Let me see if I can explain it better. The temporary risk protection says will cause harm now or in the near future. So that gets you to your initial temporary order set down. And then you go to court and find out, okay, what caused this action? How do you still feel about it now? Sergeant Jenkins testified that he believes that Mr. Davis's feelings could still be festering, not festered, festering, based on his tracking of Miss Kohler, the escalation of his dissatisfaction with this love triangle. Chief Manning testified in the same manner, that he felt that this could be something going forward. So I guess what my position is, and our position is, we're not saying that we didn't think he had a risk of future harm. The argument that the appellant is making, again, for the first time here, is that we have based our position on one incident. And since it's based on one incident, then how can we show that there will be some type of harm out in the future? Does he have a history of it, etc.? None of us can testify about what someone may do in the future. What these officers testified about is what happened in the past, how it led up to the March incident, what they believe as of the May 15th incident would lead them to believe that the RPO would be successful or should be appropriate because of these past actions and how they may lead in the future. So I'm not arguing that the statute doesn't contemplate future behavior, because all future behavior is going to be contemplative. We can't, there's no ever argument that's going to come before a court that says we need to issue an RPO because 6 months from now this person is going to go do something. We're saying that based on this competent substantial evidence that was presented at trial, these officers who the judge evaluated believe that there is the potential for him to go out and do something, and they testified to that. That they still believed that he was not where he should be, and it was appropriate.
Let me ask you another question. I haven't seen any of these. I mean, the statute's relatively new. There are no cases that I could find that have made it to the appellate level. Through your research and work for this, are there any that are roaming around on the circuit level?
Not that I'm aware of. I think we're here for the first time.
Mr. Landers, your argument, certain constitutional arguments are waived, but if the argument is that the statute is facially unconstitutional, that can be brought up the first time on appeal. So this question to you. It seems to me, arguably, the troubling language in this statute is it requires clear and convincing finding that there is a significant risk, and I have trouble with the word significant. That could, to me, arguably could mean a lot of things. It could mean a very low bar. I mean, it's a high probability of a small possibility, almost. Could be possible, could be I recognize something, could be barely credible, but it's significant, whatever, fill in the blank. Isn't the danger in this statute that the temptation is to cast a broad net? We're going to catch up a whole lot of people that are just bloviating and blowing off steam.
Well, Your Honor, we do believe that 1.071 should have been followed so the Attorney General could have had an opportunity to be involved in this from the beginning. So I understand your argument. You're saying there are certain circumstances where constitutionality could be raised at the first time at the appeal level, but we don't believe that it was properly raised in this particular case, especially a case like this. It's a new law that the Attorney General could have been on notice to join in at the trial level, and again, getting it for the first time at the appeal level. But to answer your question, the appellant talks about, thankfully, in their brief, that the RPO statute mirrors in many ways the domestic violence statute. And in fact, they point out the domestic violence statute as a shining example of well-crafted legislation. And of course, we know that the domestic violence statute has been around for a long time. If the court reads the domestic violence statute, first of all, there's a lower burden of proof, and there are less considerations for a court to consider. And in fact, one particularly stands out that says that the court can consider other behavior or conduct that may lead a person to believe that they're the victim of domestic violence. So, if Your Honor looks at the word significant and says, well, that's kind of a vague term, then I would proffer other behavior and conduct as being the widest net that could be thrown to have a domestic violence order entered against you. And as the court knows, domestic violence orders can go on forever. They can be indefinite.
Yeah, I mean, arguably the difference being in domestic violence context, I think the courts use the word imminent frequently. And that's a more substantial word. I mean, if I'm the trial judge, I'm thinking, if I let these people leave the courtroom, there's going to be a brawl in the parking lot, and I can see that and do something about it. If it's just text messaging back and forth and words back and forth, then I think a lot of those cases tend to be dismissed. But you can that domestic violence statute is a sword and shield for both of you in this case, I believe.
I agree. If there have any other questions, again, we would ask that the court affirm the lower court's ruling per curiam, and I thank you for your time.
Wait, one more question for you. I was a little bit concerned that, and I guess you can argue that about how the misunderstanding about whether the case would be continued or whether there would be a temporary would be continued, to be the hearing would be reconvened. As I understand it, Kohler didn't testify, the girlfriend didn't testify, and Davis didn't put on his direct. To me, those are the people that probably have the most knowledge about what's going on in their lives of all the witnesses. What harm would there be for us to just simply remand the case back to the trial court to reopen the evidence and hear the rest of that evidence?
Well, first of all, again, this was not an issue raised at any time during the trial or after the trial. It's raised on appeal. We don't believe it's appropriate to be heard here. And the appellant mischaracterized the time limit on this thing. This, to use Judge Brazington's terms, this trial wasn't formed in a vacuum either. We had 2 continuances of this trial. There was paper discovery, there was deposition discovery. The trial was set by agreement by the parties and counsel for May 15th for 2 hours. The trial went on for 3 hours and 15 minutes. The record will reflect that the person standing in front of Judge Brazington for the majority of that time was Mr. Miller. I questioned Chief Manning for 11 pages of testimony. He questioned Chief Manning for 19 pages of testimony. I questioned Sergeant Jenkins for 14.5 pages of testimony. He questioned Sergeant Jenkins for 19 pages of testimony. We spent 10 pages of testimony on the question of Dr. Demery and him staying in or out of the courtroom. The person who was on the stand the longest of anyone was Dr. Demery. So this was a case of trial strategy. The fact that Ms. Kohler didn't testify, or that Mr. Davis was not called on direct, is not laid at the feet of Judge Brazington or myself. It was a trial strategy. They could have limited their time that they spent cross-examining my witnesses and then direct examining Dr. Demery to get all those things in. So arguments made that, well, the would-have, could-have, should-have arguments made at appeal, I believe, would open the door to everyone coming back and saying, well, if I would have known things were going to turn out this way, I would have done them differently. This case was set. Mr. Davis had notice and opportunity to be heard. He knew what was coming on the day of May 15th because we had done the discovery, and we went through those issues. So I believe that the appellant had his day in court, and what didn't get heard on his end were choices that he made.
All right, let me ask you one last question. We'll give other side time about the procedure, which I asked your opposing counsel at the outset. This order expires a week from tomorrow, and you agree with his representation that no request to extend it has been filed as we sit here, correct?
Correct.
And obviously, you don't know what's been going on since you've been here and what might go on in the next 8 days, but at this point, is there any expectation that a request for an extension will be filed?
As of today, no, sir.
Okay.
No, sir. And that's why we think that this process worked.
All right. Thank you, Counsel.
Thank you.
Thank you.
May it please the court? I want to first just address this idea of trial strategy. It is similar to a waiver argument, and you have to know that you're actually waiving a right. There was 2.5 hours taken up by the hearing by the presentation of the Gilchrist County Sheriff's Office case. There was 45 minutes allotted to Mr. Davis for the presentation of his case. It wasn't trial strategy. The trial strategy that was presented was nobody ever said to Mr. Davis, if you decide that you want to continue, I'm stopping at 3 hours and 16 minutes. You will not be allowed to call your additional witnesses. You can't do closing arguments.
But
That
on
was
the other
never
side,
done.
was there a request for any of that? Was there a request for additional hearing time after the fact? Was there a rehearing motion? At what point did you put the trial court on notice? Judge, we didn't think we were done.
Throughout the proceeding, there had been several times where Mr. Miller had said, no, I'm going to reserve that for my opening, or I will reserve calling Mr. Davis on my direct. So he made it clear to the trial court of his expectation in that regard. Mr. Landers himself said that there had been several continuances of this hearing, and so it was an expectation by Mr. Davis and Mr. Miller that this was going to happen again. That Judge Brasington had already extended several times, knowing that this was not a rush. She had a temporary risk protection order, which she mentions when she leaves the bench, that it's going to stay in place. It stayed in place on the prior continuances as well.
But you would agree the record doesn't reflect when Judge Brasington was closing up her file and walking out the door, somebody said, Judge, now we need to set some more time on your calendar to finish the hearing.
Absolutely agree. I think there was a statement that as she was rushing off the bench, that I'll let you all know what I'm going to do. The temporary risk protection order stays in place. So I don't believe it was clear that I'm going to enter a final risk protection order or I'm not. We're done with the hearing. There will not be any continuances. But Judge Weatherall, you're right. There was not a specific statement at the end that says, okay, Judge, but I still get to call my 2 witnesses and present closing arguments, right? That was not done.
And just to close the loop, no motion for rehearing after the order came out saying, Judge, what the heck, we thought we were having a hearing.
No, in fact, there was a motion for rehearing that was filed immediately after the risk protection order was entered, and both of those issues were raised. Your Honor, I didn't get a chance to call my witnesses. I didn't get a chance to do opening. I didn't get a chance to do closing. And that was denied, which is why this appeal followed.
Let me ask you about your constitutional challenges. The as-applied challenge, do you agree that that's not properly before us at this point?
That's correct.
Okay. What about the failure to bring the Attorney General, or at least give the Attorney General's office an invitation to defend the statute on the facial challenge?
At the trial level, I believe that would have been possible and would have allowed for that as-applied challenge to be continued forward, but that was done for this appeal. We filed the notice of unconstitutional statute at the time we filed this brief, and the Attorney General has not shown up. So as it relates to the facial challenge, they did have an opportunity to present and have not made any appearance.
And your facial challenge is that the statute is vague because of the terms used, or?
It's vague and it's overbroad. Start with the fact that strict scrutiny should apply because this affects a core element of your fundamental right. This is not like it was in Norman versus State where there was just a manner in which somebody was carrying a firearm that was at issue. This is a total ban on your right to possess your firearm even in your own home, even for self-defense. And D.C. versus Heller says that's the core of your Second Amendment right. That's why we believe the statute should be presumed unconstitutional and strict scrutiny applies. Then it's vague because if you look at 3B, it talks about significant danger, doesn't say when, doesn't say how. Mr. Landers interprets it to mean no future risk. Mr. Miller and your honors have said, yeah, we think future risk is involved. In 2008, the United States Supreme Court in U.S. versus Williams defined vagueness as not being whether it's going to be possible, it's difficult to determine whether an incriminating fact has been established, but what that fact is in the first place, which is supposed to be established. Here you have two trained lawyers who can't distinguish, based on the face of this statute, whether future does or does not play a role in the final order. And that is a definition of vagueness. 3B also talks about personal injury. Is it limited to physical injury, or does it include emotional injury? 3C says, Judge, look at all relevant evidence, including but not limited to these 15 examples. 5 of those examples talk about threat of violence, but it doesn't define threat of violence. In his brief, Mr. Landers talks about credible threat, but that's a term of art. It's actually defined by Florida's stalking statute, but there's nothing in the RPO statute directing a court to look at the stalking statute for clarity, for guidance. You have one of them that talks about entirely innocent activities, buying firearms or ammunition. One of them talks about serious or recurring mental illness, but it doesn't define the mental illness or have a nexus to firearms or a threat. You got 2 that are supposed to clarify what relevant evidence is, and they say, look at relevant evidence. Those are numbers 14 and 15 of the examples. That doesn't provide direction, it provides discretion. And because you're talking about somebody's speech, threat of violence, without making it imminent, then you fall into the area of Salt versus State in 2005. Because now you're not giving any guidance and you're overstepping into somebody's First Amendment right. You're actually making somebody choose between exercising their First Amendment right, even if it's not imminent, and potentially losing their Second Amendment right. And the legislature should not force any citizen of Florida to make that decision. In this case, the order that was entered talked about a possible or potential threat. That's why she talks about Mr. Davis's training. There's no past conduct that was shown to her which indicated future violence. And now she's not covering imminent risk, she's talking about hypothetical risk. That means nobody is protected from this statute. We're all going to get angry. We might say something that we don't mean. Should we have to choose between our First and Second Amendment rights? I would say the answer to that is no. And Judge Sherritt, as with regard to the clear and convincing evidence, Sergeant Jenkins actually said that 4 days after the March 18th event, Mr. Davis was back to normal. He also said he would defer to the mental health counselor. Chief Manning said he was primarily an I don't know witness. So there was no past conduct that would indicate future risk of harm. And we would ask this court to quash the risk protection order and also to find that the statute is unconstitutional.
All right, thank you, counsel. Thank you both for your time.
Thank you.
All right, we'll be in recess again to reconstitute the panel and have the next group of lawyers head on up to the podium.
All rise.